Hello viewers, and welcome to part 5 of our screencast entitled Estate Settlement and Trust Administration in Connecticut. My name is Richard Land. I'm an attorney and a member of a Danbury, Connecticut law firm known as Chipman Mizuko. When do trustees run into trouble? In my experience, it seems to be in these 6 areas. Accountings, including problems resulting from commingling, which we mentioned earlier. Investments, or the way that trustees go about making investment decisions. Self-dealing, contractual commitments trustees make on behalf of a trust. Tort claims, including environmental problems. I'll talk about what a tort is later. And erroneous payments and distributions. Let's talk first about accountings. The trustee's obligation to account may depend on whether the trust is established by the terms of a will, that's called a testamentary trust, or by an agreement or declaration of trust, that's called a living trust. In Connecticut, a trustee of a testamentary trust is required to file accountings in the probate court, that's called a judicial accounting. In Connecticut, judicial accountings are not required for a living trust, but beneficiaries can invoke the probate court or the superior court to require accountings even for living trusts. Keep in mind that whether or not a court requires an accounting, the beneficiaries will be entitled to know about how the trustee manages the trust. And a trustee who wants to know that no beneficiary will make a claim against the trustee for a breach of the trustee's duties will want a release from the beneficiaries or the approval of a court. And in order to get that, the trustee must make adequate disclosures. That's what an account is. A disclosure of all the transactions which are made by the trustee. The accounting starts with the inventory. That's a list of every asset initially received by the trustee and the value of each asset when it was received. The accounting will report on the income generated by each asset. Often it will be necessary for the trustee to maintain a separate bookkeeping account for the income. For example, that will be necessary when the person entitled to the income of the trust is different from the person who is entitled to the principal of the trust. And when the trustee incurs expenses that are paid from the trustee might need to decide how much of the expense should be paid from income and how much from principal. When the trustee sells an asset, the trustee must be able to show to the beneficiaries whether there was a gain or loss resulting from the sale. So the trustee must report on income received and expenses paid and all principal transactions. And while the trustee is doing so, he needs to be thinking about the Connecticut Principal and Income Act, because that's where all the rules are located that identify what kind of receipts are income and what kind are principal, and to what extent expenses and taxes are to be paid out of income or principal. And, of course, such decisions are the type that the beneficiaries should be very interested in. It may be the case that, although the trust has increased in value, the income account shows very little income because all the increase was the result of increases in the value of the principal. In that case, the trustee may have the authority, under Connecticut's Principal and Income Act, to make an adjustment between the income and principal accounts to achieve a fair and reasonable result. The power in the trustee to make such an adjustment applies when the trustee invests in accordance with the Connecticut Uniform Prudent Investor Act, which incorporates the approach suggested by modern portfolio theory. That's a theory of investment that attempts to maximize return, whether consisting of principal appreciation or income, and minimize risk through the selection of different asset classes whose performances are not closely correlated. In addition, in order for the power to adjust income and principal accounts to apply, the distribution rights under the terms of the trust must be a function of income, and the trustee must determine that the trust cannot be administered fairly for the beneficiaries without an adjustment. When the trustee is trying to figure out whether such an adjustment should be made, the Connecticut Principal and Income Act requires the trustee to consider the following: the nature, purpose, and duration of the trust, the intent of the person who established the trust, the beneficiary's circumstances, the trust's need for liquidity, regular income, and capital appreciation, the nature of the assets in the trust, the amounts involved and what the income and principal accounts will look like after the adjustment, whether the trustee has discretion to pay principal or accumulate income, the effects of economic conditions including inflation and deflation, and the tax consequences. So there is quite a lot for the trustee to think about when the trustee makes adjustments, and the beneficiaries may be intensely interested in how the trustee exercises such power. Good records are extremely important, including a written record of how the trustee considers each of the criteria just described. Problems relating to investment decisions are common. The trustee will want to be able to show that his investment decisions were both authorized and made as prescribed by the Prudent Investor Act. Let's first discuss the important distinction between investments that are authorized and investments that are not authorized. A trustee finds his authority to act in powers that are actually expressed in the terms of the trust. So usually, you will see an exhaustive list of powers included in the terms of the trust, or statutory powers may be incorporated by specific reference in the trust document. So before a trustee takes action, he should be looking for that express authority, and perhaps he can find authority in what was implied by a power that is expressed. And it is important that he finds the authority because if the trustee performs an act which is not authorized, the trustee will be strictly liable for resulting losses, whether or not he can show that the decision was made prudently. That is a very important point. The trustee must make certain that the action he is taking is authorized. If there is doubt, it is best to get court approval before going through with it. Now let's talk about the Connecticut Uniform Prudent Investor Act. The point of the next several slides is that the trustee can avoid personal exposure to liability if he makes decisions consistent with the process required by the Prudent Investor Act. The Act is process-oriented, not results-oriented. Keep in mind that the Prudent Investor Act will apply unless the terms of the trust indicate that the Act should not apply. Under the Prudent Investor Act, investment decisions are evaluated in the context of the trust portfolio as a whole. An investment is evaluated on whether it is part of an overarching investment strategy based on modern portfolio theory with a focus on total return and reduction of risk. In a way, this repeals some old common law which required the trustee to justify each individual investment independently from all the other investments. Now, even if an individual investment could not be justified as a standalone investment, it can be justified if it performs a purpose related to the overall strategy. The trustee's standard of conduct is the key, not his actual investment performance. From a legal liability point of view, the question is, how did the trustee go about making his decisions, not whether it ended up being a good decision. The investment performance might be awful, and the beneficiaries may be hopping mad, but if the trustee can demonstrate that he considered all the important criteria, he very likely will be insulated from liability. So, let's talk about what the Prudent Investor Act says a trustee must consider. The trustee must consider general economic conditions, the possible effects of inflation or deflation, tax consequences of investment decisions, strategies, and distributions, the role of each investment in the overall portfolio, the expected total return from income and appreciation, related trusts and other resources of the beneficiaries, the need for liquidity, cash flow, and preservation of principal, an asset's special relationship to the purposes of the trust, the size of the portfolio, and the nature and duration of the trust. It's best for the trustee to prepare an investment policy statement which will cover all the factors required by the Prudent Investor Act. You'll find that the investment policy statement is very useful if your decisions are questioned by unhappy beneficiaries. If your performance as a trustee is being questioned in a lawsuit and an aggressive litigator is deposing you, trying to attack the decisions you make as trustee, you'll be very grateful that you have handy your investment policy statement demonstrating that you considered all the factors. In spite of the fact that there is a very good chance that it will end badly, many people decide to select family members or friends to be trustees when the family member or friend has no investment experience. Such a trustee with little knowledge and experience with investments, will need help. The Prudent Investor Act authorizes trustees to delegate their investment duties to an investment manager, but the selection of the manager must be made with care. The scope of engagement must be reasonable, and the trustee must review the manager's activities periodically. So far in discussing common problems trustees face, we have talked about accounting requirements and investment responsibilities. Now let's talk about self-dealing issues. We covered most of this in Part 4 of this screencast when we covered the trustee's duties. The trustee is to gain no personal profit from his activities as trustee other than reasonable compensation for services. So the trustee should not use his position as trustee to directly or indirectly benefit himself. For example, this means the trustee cannot compete with the trust for a transaction. That might come up, for example, when a trustee, while shopping for a good real estate investment for the trust, decides that the deal is so good he would rather purchase the property himself for his own personal benefit instead of purchasing the property for the trust. These types of situations involving self-dealing can come up in ways that are completely innocent. When that occurs and the trustee wishes to go through with a transaction that involves self-dealing, it's possible to complete the transaction, but the trustee should be careful to fully disclose the facts of the transaction to the beneficiaries and obtain their consent or to obtain court approval. Something for the trustee to keep in mind with respect to transactions that involve self-dealing is that unless the trustee obtains the necessary approvals, the transaction is void or voidable. This is especially important in real estate transactions. Suppose that George, as trustee, sells trust real estate to himself for George's own personal account. The land records would show a deed from George as trustee to George. On the face of the land records, therefore, it's clear that George engaged in an act of self-dealing. If George then tries to sell the property, the prospective buyer would be reluctant to purchase from George because the buyer would know that the transfer to George is either void or voidable. So that creates an unmarketable title in George. Assuming that the transaction would be good for the trust, and that George's motives were pure, and he was acting in good faith, George could solve the problem by asking the court to approve the sale from the trust to George, and the court's decree approving the sale would be recorded in the land records, thereby solving the problem. That's the end of Part 5 of this screencast. In Part 6, we'll continue to discuss common challenges trustees deal with, including contracts that the trustee makes, a trustee's liability for negligence, other tort claims, and environmental contamination. We'll also discuss trustee compensation. Thank you.